In this video, we will discuss what is known as the Life Act, or 245I. It's a process by which people who have come into the United States before a certain time and have been here for several years can eventually become a resident here in the United States. Under this process, there's several specific requirements. Usually, when an immigration program is announced, there's a specific requirement relating to dates and different things that have had to happen before certain dates. In this circumstance, to qualify under the Life Act, or 245I, the first requirement is to have been physically present in the United States before December 21st of the year 2000. So December 20th of the year 2000 or before, physical presence in the United States. Second, the individual has to be what's called a beneficiary, or somebody that's benefiting from a petition that was filed on their behalf before the 30th of April of the year 2001. Now, there's some technicalities with this, and sometimes the mail around those dates wasn't getting to where it needed to go on time to the USCIS offices, and so they do allow for a brief or a small exception if the mail arrived by May 3rd of the year 2001 with this application having been filed. But the important thing is that that application had to have been filed. Another thing with the application is it had to have been approvable when filed, so sort of on its face, or sometimes what they say in the legal world is prima facie eligibility. All the elements needed to approve the application had to have been present when the application was filed at that time. To be approved, they had to be in one of the categories that we've mentioned before under the consular processing categories, or a certain family member of a U.S. citizen or permanent resident to be approved at that time. So, for example, if the person was a U.S. permanent resident and tried to apply for a brother or a sister at the time, they might not have qualified. But if the person was a citizen and tried to file for one of their siblings, they probably did qualify. And there's other relationships that qualify between parents and children, spouses, things like that, right? When the application was filed on that date, it's also important to analyze the priority date. Sometimes the priority date will become current, and actually in the year 2023, when we're making this video, a lot of these dates are starting to become current in the different categories, which means that was their sort of place in line. That was the number they took, kind of like when somebody's at the DMV, they take a number and they wait for their turn, and then finally their number is called. Well, 20 years later, a lot of these applications that were filed in the year 2001, the dates are becoming current, the number's being called, and they're able to adjust their status and move on with the process. Sometimes they're not able to move forward with the process through the original petitioner, but they can use that original petition that was filed to get around one of the legal requirements that would require them to leave the country instead of just staying in the United States. So if they meet these requirements, they can usually move forward and file an application for residency, an application to show that they qualify for 245I, and then filing fees. The filing fees can be close to around $3,000, taking into account that there's a $1,000 fine that they pay as part of this process, so that they don't have to leave the country and wait for several years outside of the United States. When these are filed, then there's a process by which they wait. And it could be 2 years, could be 3 years, depending on the USCIS office. And during that wait time, they can get a work authorization and work here in the United States. One of the important analyses that has to be done before filing this type of application is to determine whether the intending immigrant, the applicant, is subject to some type of bar where they wouldn't be able to proceed with the process. The bars that are common in these situations would be like a 3-year bar if the person was in the United States, and in fact they asked this question specifically on the application. If the immigrant was in the United States for more than 180 days without any documentation and then later left at any time. Or another question would be if they're in the country for more than 365 days and then left the country at any time, right? And so if they were in the country those amounts of times without documentation and then left, then they can have a 3-year bar or a 10-year bar. And then if they come back to the United States before waiting that amount of time outside of the country, then they could have a permanent bar depending on the situation. Those types of decisions and analysis are very detailed, and it's important to meet in person with an attorney to discuss those situations. And in fact, sometimes we have to even investigate deeper and use a FOIA, or Freedom of Information Act, to request all the documentation from the immigrant's file from the government to see if we can piece together what their immigrant history looks like. So it's very important, because what happens is during those 20-something years, sometimes there's a quinceañera party and the family wants to go back and visit, or their grandma grandmother might pass away and they go to the funeral and they come in and out of the country, and every time they cross that border, they might be affecting their ability to qualify under 245I. But if it's a clean case, they were here in the country since before December 2000, and somebody petitioned for them before April of 2001, and now they're still here in the country, they don't have disqualifying immigration history, disqualifying criminal history, then they might be able to file this application, and without the need to leave the country and wait outside for a period of time, they pay that fine of $1,000 in conjunction with the other applications, and they can become a resident here in the United States. And so, as I've been discussing, there can be very technical decisions that need to be made and details that need to be considered before filing these applications. One of the risks is sometimes when these applications are denied, depending on the current administration in the government and current policies with USCIS, I have seen cases like this denied where not only it's a denial, but then they send the person to removal proceedings with an immigration judge. And so there's very serious consequences if the person isn't approved for 245I and for the I-485 or the residency application, which is why it's very important to meet with an attorney that's had experience over the years filing 245I cases and doing a deep dive analysis to understand, is it a proper procedure to file this application, or maybe should I wait for some other thing to come about that would help, in my immigration circumstance. Other things that might happen under 245I, as I mentioned before, the original application priority date hasn't come about, but now the immigrant has a U.S. citizen son or daughter who's over 21. So maybe they don't even have to wait for the priority date. They can use a new petition from the daughter or the son that's 21 years old and is a U.S. citizen to apply ahead of time. Sometimes the original petitioner might pass away, and then that causes some circumstances that should be looked at. Different things might happen, which again is why it's important to consult directly with an attorney. It doesn't have to be me, just somebody that has experience in 245I. We have a lot of experience. We've done a lot of those types of cases, have several clients who are not only green card holders now, but are now even U.S. citizens, and they started out with the 245I process, and we've been able to be successful in a lot of those areas. So if you'd like to discuss your case with us, you can find information in the description below how to contact us. Otherwise, my suggestion is just make sure you talk to an attorney before moving forward in this circumstance with 245I, with the Life Act, because even though a lot of people get excited about these processes, there can be a lot of technical things that need to be discussed with an attorney before moving forward.